U.S. Supreme Court. United States v. Nixon, 418 U.S. 683, 1974, United States v. Nixon. Number 73766. Argued July 8, 1974. Decided July 24, 1974, 418 Thrist. 418 683. Certiorari, before judgment to the United States Court of Appeals for the District of Columbia Circuit. Syllabus: following indictment alleging violation of federal statutes by certain staff members of the White House and political supporters of the president, the special prosecutor filed a motion under Fed Rule Crim Proc 17C for a subpoena ducis tecum for the production before trial of certain tapes and documents relating to precisely identified conversations and meetings between the president and others. The president, claiming executive privilege, filed a motion to quash the subpoena. The district court, after treating the subpoenaed material as presumptively privileged, concluded that the special prosecutor had made a sufficient showing to rebut the presumption and that the requirements of Rule 7C had been satisfied. The court thereafter issued an order for an in-camera examination of the subpoenaed material, having rejected the president's contentions: A, that the dispute between him and the special prosecutor was non-justiciable as an intra-executive conflict, and B, that the judiciary lacked authority to review the president's assertion of executive privilege. The court stayed its order pending appellate review, which the president then sought in the Court of Appeals. The special prosecutor then filed in this court a petition for a writ of certiorari before judgment, number 73-1766, and the president filed a cross petition for such a writ challenging the grand jury action, number 73-1834. The court granted both petitions. Held: 1. The district court's order was appealable as a final order under 28 U.S.C. Sacrif 1291, was therefore properly in the Court of Appeals, 28 U.S.C. Sacrif 1254, when the petition for certiorari before judgment was filed in this court and is now properly before this court for review. Although such an order is normally not final and subject to appeal, an exception is made in a limited class of page 4 and 18 U84 cases where denial of immediate review would render impossible any review whatsoever of an individual's claims. United States v. Ryan, 402 U.S. 530, 402 U.S. 533. Such an exception is proper in the unique circumstances of this case, where it would be inappropriate to subject the president to the procedure of securing review by resisting the order, and inappropriate to require that the district court proceed by a traditional contempt citation in order to provide appellate review. pp. 418 U.S. 690-692. 2. The dispute between the special prosecutor and the president presents a justiciable controversy. pp. 418 U.S. 692-697. A. The mere assertion of an intra-branch dispute without more does not defeat federal jurisdiction. United States v. ICC 337 U.S. 426, p. 418 U.S. 693. B. The Attorney General, by regulation, has conferred upon the special prosecutor unique tenure and authority to represent the United States, and has given the special prosecutor explicit power to contest the invocation of executive privilege in seeking evidence deemed relevant to the performance of his specially delegated duties. While the regulation remains in effect, the executive branch is bound by it. United States ex rel. Icardi v. Shaughnessy, 347 U.S. by 260, pp. 418 U.S. 694-96. C. The action of the special prosecutor within the scope of his express authority, seeking specified evidence preliminarily determined to be relevant and admissible in the pending criminal case, and the president's assertion of privilege in opposition thereto, present issues of a type which are traditionally justiciable. United States v. ICC supra, at 337 U.S. 430, and the fact that both litigants are officers of the executive branch is not a bar to justiciability. 418 U.S. 696-697. 3. From this court's examination of the material submitted by the special prosecutor in support of his motion for the subpoena, much of which is under seal, it is clear that the district court's denial of the motion to quash comported with Rule 17C, and that the special prosecutor has made a sufficient showing to justify a subpoena for production before trial. pp. 4 and 18, U.S. 697 to 702. 4. Neither the doctrine of separation of powers nor the generalized need for confidentiality of high-level communications without more can sustain an absolute unqualified presidential privilege of immunity from judicial process under all circumstances. CEG 5 U.S. Madison, 1 Cranch 137, 5 U.S. 177, Baker v. Carr, 369 U.N. 86, 369 U.S. 211, absent a claim of need to protect military, diplomatic, or sensitive national security secrets. The confidentiality of page 4 and 18 U.S. 685. Presidential communications is not significantly diminished by producing material for a criminal trial under the protected conditions of in-camera inspection, and any absolute executive privilege under Art 2 of the Constitution would plainly conflict with the function of the courts under the Constitution. pp. 418 U.S. 703 to 707. 5. Although the courts will afford the utmost deference to presidential acts in the performance of an Art 2 function, United States v. Burr, 25 F. Cass 187, 190, 191 to 192, number 14, 1694, when a claim of presidential privilege as to materials subpoenaed for use in a criminal trial is based, as it is here, not on the ground that military or diplomatic secrets are implicated, but merely on the ground of a generalized interest in confidentiality, the President's generalized assertion of privilege must yield to the demonstrated specific need for evidence in a pending criminal trial and the fundamental demands of due process of law in the fair administration of criminal justice. pp. 418 U.S. 707 to 713. 6. On the basis of this court's examination of the record, it cannot be concluded that the district court erred in ordering in-camera examination of the subpoenaed material, which shall now forthwith be transmitted to the district court. pp. 418 U.S. 713 to 714. Since a president's communications encompass a vastly wider range of sensitive material than would be true of an ordinary individual, the public interest requires that presidential confidentiality be afforded the greatest protection, consistent with the fair administration of justice, and the district court has a heavy responsibility to ensure that material involving presidential conversations irrelevant to or inadmissible in the criminal prosecution be accorded the high degree of respect due a president, and that such material be returned under seal to its lawful custodian. Until released to the special prosecutor, no in-camera material is to be released to anyone. 418 U.S. 747 to 16. Number 73-1766, 377 F. Sup. 1326 affirmed. Number 73-1834 certiorari dismissed as improvidently granted. Berger, C.J., delivered the opinion of the court in which all members joined except Rehnquist J., who took no part in the consideration or decision of the cases. Page 4 and 18 U.S. 686. Mercer Chief Justice Berger delivered the opinion of the court. This litigation presents for review the denial of a motion filed in the district court on behalf of the President of the United States in the case of United States v. Mitchell, D.C. Cram, number 7110, to quash a third-party subpoena ducis tecum issued by the United States District Court for the District of Columbia, pursuant to Fed Rule Crim Proc 17C. The subpoena directed the President to produce certain tape recordings and documents relating to his conversations with aides and advisors. The court rejected the President's claims of absolute executive privilege, of lack of jurisdiction, and of failure to satisfy the requirements of Rule 17C. The President appealed to the Court of Appeals. We granted both the United States petition for certiorari before judgment, number 7, 1766, and also the President's cross petition for certiorari, page 4 and 18 U.S. 687, before judgment, number 73, 1834, because of the public importance of the issues presented and the need for their prompt resolution. 417 U.S. 927 and 960, 1974. On March 1, 1974, a grand jury of the United States District Court for the District of Columbia returned an indictment charging 7 named individuals with various offenses, including conspiracy to defraud the United States and to obstruct justice. Although he was not designated as such in the indictment, the grand jury named the president, among others, as an unindicted co-conspirator. On April 18, 1974, upon motion of the Special Bimmer, page 418 U.S.C. 8, prosecutor, CN8 Infra, a subpoena ducis tecum was issued pursuant to Rule 7C to the President by the United States District Court and made returnable on May 2, 1974. This subpoena required the production in advance of the September 9th trial date of certain tapes, memoranda, papers, transcripts, or other writings relating to certain precisely identified meetings between the President and others. The special prosecutor was able to fix the time, place, and persons present at these discussions because the White House daily logs and appointment records had been delivered to him. On April 30th, the President publicly released edited transcripts of 43 conversations. Portions of 20 conversations subject to subpoena in the present case were included. On May 1, 1974, the President's counsel filed a special appearance and a motion to quash the subpoena under Rule 17C. This motion was accompanied by a formal claim of privilege. At a subsequent hearing, six further motions to expunge the grand jury's action naming the President as an unindicted co-conspirator and for protective orders against the disclosure of that information were filed or raised orally by counsel for the President. On May 20, 1974, the District Court denied the motion to quash and the motions to expunge and for protective orders, 377 F. Sup. 1326. It further ordered the President or any subordinate officer, official, or employee with custody or control of the documents or map. Page 418 U.S. 689. Object subpoenaed ID at 1331 to deliver to the District Court on or before May 31, 1974, the originals of all subpoenaed items as well as an index and analysis of those items, together with tape copies of those portions of the subpoenaed recordings for which transcripts had been released to the public by the President on April 30th. The District Court rejected jurisdictional challenges based on a contention that the dispute was non-justiciable because it was between the Special Prosecutor and the Chief Executive and hence intra-executive in character. It also rejected the contention that the judiciary was without authority to review an assertion of executive privilege by the President. The court's rejection of the first challenge was based on the authority and powers vested in the Special Prosecutor by the regulation promulgated by the Attorney General. The court concluded that a justiciable controversy was presented. The second challenge was held to be foreclosed by the decision in Nixon v. Sirica, 159 U.S. App D 58, 487 F. Sector B 700, 1973. The District Court held that the judiciary, not the President, was the final arbiter of a claim of executive privilege. The court concluded that, under the circumstances of this case, the presumptive privilege was overcome by the Special Prosecutor's prima facie demonstration of need sufficiently compelling to warrant judicial examination in chambers. 377 F. Sup. at 1330. The court held, finally, that the Special Prosecutor had satisfied the requirements of Rule 17C. The District Court stayed its order pending appellate review on condition that review was sought before 4 p.m. May 24th. The court further provided that matters filed under seal remain under seal when transmitted as part of the record. On May 24th, 1974, the President filed a timely notice of appeal from the District Court order, and the certified record from the District Court was docketed in the United, page 418 U.S. 690, States Court of Appeals for the District of Columbia Circuit. On the same day, the President also filed a petition for writ of mandamus in the Court of Appeals, seeking review of the District Court order. Later on, May 24th, the Special Prosecutor also filed in this court a petition for a writ of certiorari before judgment. On May 31st, the petition was granted with an expedited briefing schedule, 417 U.S. 927. On June 6th, the President filed under seal a cross petition for writ of certiorari before judgment. This cross petition was granted June 1st, 1974, 470 U.S. 960, and the case was set for argument on July 8th, 1974. Aye. The threshold question presented is whether the May 20th, 1974 order of the District Court was an appealable order, and whether this case was properly in the Court of Appeals when the petition for certiorari was filed in this court. 28 U.S.C. Subtraction 1254. The Court of Appeals jurisdiction under 28 U.S.C. Paragraph 1291 encompasses only final decisions of the district courts. Since the appeal is timely filed and all other procedural requirements were met, the petition is properly before this court for consideration if the district court order was final. 28 U.S.C. Second 1254-1, 2101E. The finality requirement of 28 U.S.C. Paragraph 1291 embodies a strong congressional policy against piecemeal reviews and against obstructing or impeding an ongoing judicial proceeding by interlocutory appeals. See E.G. Cobbledick v. United States, 309 U.S. 323, 39 U.S. 324 to 326, 1940. This requirement ordinarily promotes judicial efficiency and hastens the ultimate termination of litigation. In applying this principle to an order denying a motion to quash and requiring the production of evidence pursuant, page 418 U.S. 691, to a subpoena ducis tecum, it has been repeatedly held that the order is not final and hence not appealable. United States v. Ryan, 402 U.S. 530, 402 U.S. 532, 1971, Cobbledick v. United States Supra, Alexander v. United States, 2117, 1906. This court has consistently held that the necessity for expedition in the administration of the criminal law justifies putting one who seeks to resist the production of desired information to a choice between compliance with the trial court's order to produce prior to any review of that order and resistance to that order with the concomitant possibility of an adjudication of contempt if his claims are rejected on appeal. United States v. Ryan, Supra at 402 U.S. 533. The requirement of submitting to contempt, however, is not without exception, and in some instances the purposes underlying the finality rule require a different result. For example, in Perlman v. United States, 247 U.S. 7, 1918, a subpoena had been directed to a third party requesting certain exhibits. The appellant who owned the exhibits sought to raise a claim of privilege. The court held an order compelling production was appealable because it was unlikely that the third party would risk a contempt citation in order to allow immediate review of the appellant's claim of privilege. I'd 247 U.S. 1213. That case fell within the limited class of cases where denial of immediate review would render impossible any review whatsoever of an individual's claims. United States v. Ryan, Supra at 402-33. Here, too, the traditional contempt avenue to immediate appeal is peculiarly inappropriate due to the unique setting in which the question arises. To require a President of the United States to place himself in the posture of disobeying an order of a court merely to trigger the procedural mechanism for review of the ruling would be, page 418 U.S. 692, unseemly, and would present an unnecessary occasion for constitutional confrontation between two branches of the government. Similarly, a federal judge should not be placed in the posture of issuing a citation to a president simply in order to invoke review. The issue whether a president can be cited for contempt could itself engender protracted litigation and would further delay both review on the merits of his claim of privilege and the ultimate termination of the underlying criminal action for which his evidence is sought. These considerations lead us to conclude that the order of the district court was an appealable order. The appeal from that order was therefore properly in the Court of Appeals, and the case is now properly before this court on the writ of certiorari before judgment. 28 U.S.C. Paragraph 1254, 28 U.S.C. / 2101E. Gay v. Ruff, 292 U.S. 25 U.S. 30, 1930, footnote 7.
I. Justiciability.
In the district court, the President's counsel argued that the court lacked jurisdiction to issue the subpoena because the matter was an intra-branch dispute between a subordinate and superior officer of the executive branch, and hence not subject to judicial resolution. That argument has been renewed in this court with emphasis on the contention that the dispute does not present a case or controversy which can be adjudicated in the federal courts. The President's counsel argues that the federal courts should not intrude into areas committed to the other branches of government. Page 418 U.S. 693. He views the present dispute as essentially a jurisdictional dispute within the executive branch, which he analogizes to a dispute between two congressional committees. Since the executive branch has exclusive authority and absolute discretion to decide whether to prosecute a case, confiscation cases 7 Wall 4/1869, United States v. Cox 342 F 167 CA5, cert denied subnom Cox v. Holber 381 U.S. 935 1965, it is contended that a president's decision is final in determining what evidence is to be used in a given criminal case. Although his counsel concedes that the president had delegated certain specific powers to the special prosecutor, he has not waived nor delegated to the special prosecutor the president's duty to claim privilege as to all materials which fall within the president's inherent authority to refuse to disclose to any executive officer. Brief for the President 42. The special prosecutor's demand for the items therefore presents, in the view of the President's counsel, a political question under Baker v. Carr 369 U.S. 186, 1962, since it involves a textually demonstrable grant of power under Art 2. The mere assertion of a claim of an intra-branch dispute, without more, has never operated to defeat federal jurisdiction. Justiciability does not depend on such a surface inquiry. In United States v. ICC 337 U.S. 6, 1949, the court observed, courts must look behind names that symbolize the parties to determine whether a justiciable case or controversy is presented. Ide at 337 U.S. 430. See also Powell v. McCormack, 395 U.S. 486, 1969. ICC v. Jersey City, 322 U.S. 503, 1944. United States ex rel. Chapman v. FPC, 345 U.S. 153. Secretary of Agriculture v. United States, 347 U.S. 645, 1954. FMB v. Isbranson Co., 356 U.S. 481, 356 U.S. 483 and 2, 1958. United States v. Marine Bank Corporation, Anti-P, 418 U.S. 602. And United States v. Connecticut National Bank, Ante-P 418 U.S. 656. Page 418 U.S. 694. Our starting point is the nature of the proceeding for which the evidence is sought, here a pending criminal prosecution. It is a judicial proceeding in a federal court alleging violation of federal laws and is brought in the name of the United States as sovereign. Berger v. United States 295 U.S. 78, 295 U.S. 88, 1935. Under the authority of Art 22, Stagger 2, Congress has vested in the Attorney General the power to conduct the criminal litigation of the United States government. 28 U.S.C. Section 516. It has also vested in him the power to appoint subordinate officers to assist him in the discharge of his duties. 28 U.S.C. Paragraph 509, 510, 515, 533. Acting pursuant to those statutes, the Attorney General has delegated the authority to represent the United States in these particular matters to a special prosecutor with unique authority and tenure. The regulation gives the page 418 U.S. 695. Special prosecutor explicit power to contest the invocation of executive privilege in the process of seeking evidence deemed relevant to the performance of these specially delegated duties. 39 8 Fed Reg 30739 as amended by 38 Fed Reg 32805. So long as this regulation is extant, it has the force of law. In United States ex rel. Accardi v. Shaughnessy 347 U.S. 260 1954, regulations of the Attorney General delegated certain of his discretionary powers to the board. Page 418 U.S. 696. Of immigration appeals and required that board to exercise its own discretion on appeals in deportation cases. The court held that so long as the Attorney General's regulations remained operative, he denied himself the authority to exercise the discretion delegated to the board, even though the original authority was his and he could reassert it by amending the regulations. Service v. Dulles 354 U.S. 363. 354 U.S. 388, 1957. And Vettorelli v. Seaton, 359 U.S. 535, 1959, reaffirmed the basic holding of Accardi. Here, as in Accardi, it is theoretically possible for the Attorney General to amend or revoke the regulation defining the special prosecutor's authority. But he has not done so. So long as this regulation remains in force, the executive branch is bound by it, and indeed the United States, as the sovereign composed of the three branches, is bound to respect and to enforce it. Moreover, the delegation of authority to the special prosecutor in this case is not an ordinary delegation by the Attorney General to a subordinate officer. With the authorization of the President, the acting Attorney General provided in the regulation that the special prosecutor was not to be removed without the consensus of 8 designated leaders of Congress, N8, supra. The demands of and the resistance to the subpoena present an obvious controversy in the ordinary sense, but that alone is not sufficient to meet constitutional standards. In the constitutional sense, controversy means more than disagreement and conflict. Rather, it means the kind of controversy courts traditionally resolve. Here, page 418 U.S. 697, at issue is the production or non-production of specified evidence deemed by the special prosecutor to be relevant and admissible in a pending criminal case. It is sought by one official of the executive branch within the scope of his express authority. It is resisted by the chief executive on the ground of his duty to preserve the confidentiality of the communications of the President. Whatever the correct answer on the merits, these issues are of a type which are traditionally justiciable. United States v. 337 U.S. at 337 U.S. 430. The independent special prosecutor, with his asserted need for the subpoenaed material in the underlying criminal prosecution, is opposed by the President with his steadfast assertion of privilege against disclosure of the material. This setting assures there is that concrete adverseness which sharpens the presentation of issues upon which the court so largely depends for illumination of difficult constitutional questions. Baker v. Carr, 369 U.S. at 369 U.S. 204. Moreover, since the matter is one arising in the regular course of a federal criminal prosecution, it is within the traditional scope of Art 3 power. Ide at 369 U.S. 198. In light of the uniqueness of the setting in which the conflict arises, the fact that both parties are officer of the executive branch cannot be viewed as a barrier to justiciability. It would be inconsistent with the applicable law and regulation and the unique facts of this case to conclude other than that the special prosecutor has standing to bring this action and that a justiciable controversy is presented for decision. The subpoena ducis tecum is challenged on the ground that the special prosecutor failed to satisfy the requirements of Fed Rule Crim Proc 17C, which governs, page 418 U.S. 698, the issuance of subpoenas ducis tecum in federal criminal proceedings. If we sustained this challenge, there would be no occasion to reach the claim of privilege asserted with respect to the subpoenaed material. Thus, we turn to the question whether the requirements of Rule 7C have been satisfied. See Arkansas-Louisiana Gas Co. v. Deputy of Public Utilities, 304 U.S. 61, 304 U.S. 64, 1938, Ashwander v. TVA, 297 U.S., 288, 297 U.S. 346, 47, 1936, Brandeis J. concurring. Rule 7 provides, a subpoena may also command the person to whom it is directed to produce the books, papers, documents, or other objects designated therein. The court on motion made promptly may quash or modify the subpoena if compliance would be unreasonable or oppressive. The court may direct that books, papers, documents, or objects designated in the subpoena be produced before the court at a time prior to the trial or prior to the time when they are to be offered in evidence, and may upon their production permit the books, papers, documents, or objects, or portions thereof to be inspected by the parties and their attorneys. A subpoena for documents may be quashed if their production would be unreasonable or oppressive, but not otherwise. The leading case in this court interpreting this standard is Bowman Dairy Co. v. United States, 341 U.S. 214, 1951. This case recognized certain fundamental characteristics of the subpoena ducis tecum in criminal cases. 1. It was not intended to provide a means of discovery for criminal cases, I'd at 341 U.S. 220. 2. Its chief innovation was to expedite the trial by providing a time and place before trial for the inspection of page 418 U.S. 699, subpoenaed materials, I bid. As both parties agree, cases decided in the wake of Bowman have generally followed Judge Weinfeld's formulation in United States v. Iozia, 13 et RD 335, 338, MI 1952, as to the required showing. Under this test, in order to require production prior to trial, the moving party must show, 1. That the documents are evidentiary and relevant, 2. That they are not otherwise procurable reasonably in advance of trial by exercise of due diligence, 3. That the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial, and 4. That, page 418 U.S. 700, the application is made in good faith and is not intended as a general fishing expedition. Against this background, the special prosecutor, in order to carry his burden, must clear 3 hurdles: 1. Relevancy, 2. Admissibility, 3. Specificity. Our own review of the record necessarily affords a less comprehensive view of the total situation than was available to the trial judge, and we are unwilling to conclude that the district court erred in the evaluation of the special prosecutor's showing under Rule 17c. Our conclusion is based on the record before us, much of which is under seal. Of course, the contents of the subpoenaed tapes could not at that stage be described fully by the special prosecutor, but there was a sufficient likelihood that each of the tapes contains conversations relevant to the offenses charged in the indictment. United States v. Gross, 24 FRD 138, SDNY 1959. With respect to many of the tapes, the special prosecutor offered the sworn testimony or statements of one or more of the participants in the conversations as to what was said at the time. As for the remainder of the tapes, the identity of the participants and the time and place of the conversations, taken in their total context, permit a rational inference that at least part of the conversations relate to the offenses charged in the indictment. We also conclude there was a sufficient preliminary showing that each of the subpoenaed tapes contains evidence admissible with respect to the offenses charged in the indictment. The most cogent objection to the admissibility of the taped conversations here at issue is that they are a collection of out-of-court statements by declarants who will not be subject to cross-examination, and that the statements are therefore inadmissible hearsay. Here, however, most of the tapes apparently contain conversations, page 418 U.S. 701, to which one or more of the defendant named in the indictment were party. The hearsay rule does not automatically bar all out-of-court statements by a defendant in a criminal case. Declarations by one defendant may also be admissible against other defendant upon a sufficient showing by independent evidence of a conspiracy among one or more other defendants and the declarant, and if the declarations at issue were in furtherance of that conspiracy. The same is true of declarations of co-conspirators who are not defendants in the case on trial. Dutton v. Evans, 400 U.S. 74, 400 U.S. 81, 1970. Recorded conversations may also be admissible for the limited purpose of impeaching the credibility of any defendant who testifies or any other co-conspirator who testifies. Generally, the need for evidence to impeach witnesses is insufficient to require its production in advance of trial. C.E.G. United States v. Carter, 15 FRD 367, page 418 U.S. 72, 371 D.C. 1954. Here, however, there are other valid potential evidentiary uses for the same material, and the analysis and possible transcription of the tapes may take a significant period of time. Accordingly, we cannot conclude that the district court erred in authorizing the issuance of the subpoena ducis tecum. Enforcement of a pretrial subpoena ducis tecum must necessarily be committed to the sound discretion of the trial court. since the necessity for the subpoena most often turns upon a determination of factual issues. Without a determination of arbitrariness or that the trial court finding was without record support, an appellate court will not ordinarily disturb a finding that the applicant for a subpoena complied with Rule 17C. See E.g. Sue v. Chicago Transit Authority 279F 416 419 CA 7 1960, Shotkin v. Nelson 146 W4 and 2 CA 10 1944. In a case such as this, however, where a subpoena is directed to a President of the United States, appellate review in deference to a coordinate branch of government should be particularly meticulous to ensure that the standards of Rule 17C have been correctly applied. United States v. Burr, 25 FCAS 3034, number 1492D, CCVA, 1807. From our examination of the materials submitted by the special prosecutor to the district court in support of his motion for the subpoena, we are persuaded that the district court's denial of the President's motion to quash the subpoena was consistent with Rule 17C. We also conclude that the special prosecutor has made a sufficient showing to justify a subpoena for production before trial. The subpoenaed materials are not available from any other source, and their examination and processing should not await trial in the circumstances shown. Bowman Dairy Co. v. United States 341 U 14 1951, United States v. Iozia 13 Hardy 335 SDNY 1952. Page 418 U.S. 703. If the claim of privilege, having determined that the requirements of Rule 17C were satisfied, we turn to the claim that the subpoena should be quashed because it demands confidential conversations between a president and his close advisors that it would be inconsistent with the public interest to produce. App 48A. The first contention is a broad claim that the separation of powers doctrine precludes judicial review of a president's claim of privilege. The second contention is that if he does not prevail on the claim of absolute privilege, the court should hold as a matter of constitutional law that the privilege prevails over the subpoena ducis tecum. In the performance of assigned constitutional duties, each branch of the government must initially interpret the Constitution, and the interpretation of its powers by any branch is due great respect from the others. The President's counsel, as we have noted, reads the Constitution as providing an absolute privilege of confidentiality for all presidential communications. Many decisions of this court, however, have unequivocally reaffirmed the holding of Marbury v. Madison, 1 Cranston 37, 1803, that it is emphatically the province and duty of the judicial department to say what the law is. At 5 U.S. 177, no holding of the court has defined the scope of judicial power specifically relating to the enforcement of a subpoena for confidential presidential communications for use in a criminal prosecution, but other exercises of power by the executive branch and the legislative branch have been found invalid as in conflict with the Constitution. Powell v. McCormack, 395 U.S. 486, 1969, Youngstown Sheet and Tube Co. v. 343 U.S. 579, 1952. In A, page 418 U.S. 74, series of cases, the court interpreted the explicit immunity conferred by express provisions of the Constitution on members of the House and Senate by the speech or debate clause, U.S. Const. Art 1, Pac. 6. Doe v. McMillan, 412 U.S. 36, 1973. Gravel v. United States, 400 New 8 U.S. 606, 1972. United States Brewster, 408 U.S. 5, 1970. United States v. Johnson, 383 U.S. 169, 1966. Since this court has consistently exercised the power to construe and delineate claims arising under express powers, it must follow that the court has authority to interpret claims with respect to powers alleged to derive from enumerated powers. Our system of government requires that federal courts on occasion interpret the Constitution in a manner at variance with the construction given the document by another branch. Powell v. McCormack, Supra at 395 U.S. 549, and in Baker v. Carr, 369 U.S. at 369 U.S. 211, the court stated, deciding whether a matter has in any measure been committed by the Constitution to another branch of government, or whether the action of that branch exceeds whatever authority has been committed, is itself a delicate exercise in constitutional interpretation, and is a responsibility of this court as ultimate interpreter of the Constitution. Notwithstanding the deference each branch must accord the others, the judicial power of the United States, vested in the federal courts by Article 3 for F1 of the Constitution, can no more be shared with the executive branch than the chief executive, for example, can share with the judiciary the veto power, or the Congress share with the judiciary the power to override a presidential veto. Any other conclusion would be contrary to the basic concept of separation of powers and the checks and balances that flow from the scheme of a tripartite government. The Federalist, number 47, p. 313, S. Middle ed., page 418 U.S. 705, 1938. We therefore reaffirm that it is the province and duty of this court to say what the law is with respect to the claim of privilege presented in this case. Marbury v. Madison Supra at 5 U.S. 177. B. In support of his claim of absolute privilege, the President's counsel urges two grounds, one of which is common to all governments, and one of which is peculiar to our system of separation of powers. The first ground is the valid need for protection of communications between high government officials and those who advise and assist them in the performance of their manifold duties. The importance of this confidentiality is too plain to require further discussion. Human experience teaches that those who expect public dissemination of their remarks may well temper candor with a concern for appearances and for their own interests to the detriment of the decision-making process. Whatever the nature of the privilege of confidentiality of presidential communications in the exercise of Art Not 2 powers, the privilege can be said to derive from the supremacy of each branch within its own assigned area of constitutional duties. Certain powers and privileges flow from the nature of enumerated powers. The protection of the confidentiality of, page 418 U.S. 76, presidential communications has similar constitutional underpinnings. The second ground asserted by the President's counsel in support of the claim of absolute privilege rests on the doctrine of separation of powers. Here it is argued that the independence of the executive branch within its own sphere, Humphrey's Executor v. United States, 295 U.S. 602, 295 U.S. 629 to 635, Kilbourne v. Thompson, Tone 3 U.S. 168, Tone 3 U.S. 190 to 191, 1881, insulates a president from a judicial subpoena in an ongoing criminal prosecution and thereby protects confidential presidential communications. However, neither the doctrine of separation of powers nor the need for confidentiality of high-level communications without more can sustain an absolute unqualified presidential privilege of immunity from judicial process under all circumstances. The President's need for complete candor and objectivity from advisors calls for great deference from the courts. However, when the privilege depends solely on the broad, undifferentiated claim of public interest in the confidentiality of such conversations, a confrontation with other values arises. Absent a claim of need to protect military, diplomatic, or sensitive national security secrets, we find it difficult to accept the argument that even the very important interest in confidentiality of presidential communications is significantly diminished by production of such material for in-camera inspection with all the protection that a district court will be obliged to provide. Page 418 U.S. 77. The impediment that an absolute unqualified privilege would place in the way of the primary constitutional duty of the judicial branch to do justice in criminal prosecutions would plainly conflict with the function of the courts under Art 3. In designing the structure of our government and dividing and allocating the sovereign power among three co-equal branches, the framers of the Constitution sought to provide a comprehensive system, but the separate powers were not intended to operate with absolute independence. While the Constitution diffuses power the better to secure liberty, it also contemplates that practice will integrate the dispersed powers into a workable government. It enjoins upon its branches separateness but interdependence, autonomy but reciprocity. Youngstown Sheet and Tube Co. v. Sawyer, 343 U.S. at 343, U.S. 635, Jackson J. concurring. To read the Art 2 powers of the President as providing an absolute privilege as against a subpoena, essential to enforcement of criminal statutes, on no more than a generalized claim of the public interest in confidentiality of non-military and non-diplomatic discussions, would upset the constitutional balance of a workable government and gravely impair the role of the courts under Art 3. C. Since we conclude that the legitimate needs of the judicial process may outweigh presidential privilege, it is necessary to resolve those competing interests in a manner that preserves the essential functions of each branch. The right, and indeed the duty to resolve that question, does not free the judiciary from according high respect to the representations made on behalf of the President. United States v. Burr, 25 F. Cass, 187, 190, 91, 914, Naltown 6 Hangs 94, CC va 1807. Page 4 and 18, U.S. 708. The expectation of a president to the confidentiality of his conversations and correspondence, like the claim of confidentiality of judicial deliberations, for example, has all the values to which we accord deference for the privacy of all citizens, and added to those values is the necessity for protection of the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making. A president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way many would be unwilling to express, except privately. These are the considerations justifying a presumptive privilege for presidential communications. The privilege is fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. In Nixon v. Sirica, 159 U.S. App. D.C. 58, 487 D. 700, 1973, the Court of Appeals held that such presidential communications are presumptively privileged, I'd at 75, 487 F. 2D at 717, and this position is accepted by both parties in the present litigation. We agree with Mr. Chief Justice Marshall's observation, therefore, that in no case of his kind would a court be required to proceed against the President as against an ordinary individual. United States v. Burr, 25 F. Cass at 192. But this presumptive privilege must be considered in light of our historic commitment to the rule of law. This, page 4 and 18, U.S. 79, is nowhere more profoundly manifest than in our view that the twofold aim of criminal justice is that guilt shall not escape or innocence suffer. Berger v. United States, 295 U.S. at 295 U.S. 88. We have elected to employ an adversary system of criminal justice in which the parties contest all issues before a court of law. The need to develop all relevant facts in the adversary system is both fundamental and comprehensive. The ends of criminal justice would be defeated if judgments were to be founded on a partial or speculative presentation of the facts. The very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or by the defense. Only recently the court restated the ancient proposition of law, albeit in the context of a grand jury inquiry rather than a trial, that the public has a right to every man's evidence, except for those persons protected by a constitutional common law or statutory privilege. United States v. Bryan, 339 U.S. 331, 1950. Blackmer v. United States, 284 U.S. 421, 284 U.S. 438, 1932. Brandsburg v. Hayes, 408 U.S. 665, 408 U.S. 687-82. The privileges referred to by the court are designed to protect weighty and legitimate competing interests. Thus, the Fifth Amendment to the Constitution provides that no man shall be compelled in any criminal case to be a witness against himself. And generally, an attorney or a priest may not be required to disclose what has been revealed in professional confidence. These and other interests are recognized in law by privileges, page 418 U.S. 710. against forced disclosure established in the Constitution by statute or at common law. Whatever their origins, these exceptions to the demand for every man's evidence are not lightly created nor expansively construed, for they are in derogation of the search for truth. In this case, the President challenges a subpoena served on him as a third party, requiring the production of materials for use in a criminal prosecution. He does so on the claim that he has a privilege against disclosure of confidential communications. He does not place his claim of privilege on the ground they are military or diplomatic secrets. As to these areas of Art 2 duties, the courts have traditionally shown the utmost deference to presidential responsibilities. In C&S Airlines v. Waterman SS Corp. 333 U.S. 103, 333 U.S. 111, 1948, dealing with presidential authority involving foreign policy considerations, the court said, "The President, both as Commander-in-Chief and as the nation's organ for foreign affairs, has available intelligence services whose reports are not and ought not to be published to the world. It would be intolerable that courts, without the relevant information, should review and perhaps nullify actions of the executive taken on information properly held secret." In United States v. Reynolds 345 U.S. 1, 1953, dealing, page 418 U.S. 711, with a claimant's demand for evidence in a Tort Claims Act case against the government, the court said, "It may be possible to satisfy the court, from all the circumstances of the case, that there is a reasonable danger that compulsion of the evidence will expose military matters which, in the interest of national security, should not be divulged. When this is the case, the occasion for the privilege is appropriate, and the court should not jeopardize the security which the privilege is meant to protect by insisting upon an examination of the evidence, even by the judge alone in chambers." Eyed at 345 U.S. 10. No case of the court, however, has extended this high degree of deference to a president's generalized interest in confidentiality. Nowhere in the Constitution, as we have noted earlier, is there any explicit reference to a privilege of confidentiality. Yet to the extent this interest relates to the effective discharge of a president's powers, it is constitutionally based. The right to the production of all evidence at a criminal trial similarly has constitutional dimensions. The Sixth Amendment explicitly confers upon every defendant in a criminal trial the right to be confronted with the witnesses against him and to have compulsory process for obtaining witnesses in his favor. Moreover, the Fifth Amendment also guarantees that no person shall be deprived of liberty without due process of law. It is the manifest duty of the courts to vindicate those guarantees and to accomplish that. It is essential that all relevant and admissible evidence be produced. In this case, we must weigh the importance of the general privilege of confidentiality of presidential communications in performance of the President's responsibilities against the inroads of such a privilege on the fair route. Page 418 U.S. 712, Administration of Criminal Justice. The interest in preserving confidentiality is weighty indeed and entitled to great respect. However, we cannot conclude that advisors will be moved to temper the candor of their remarks by the infrequent occasions of disclosure because of the possibility that such conversations will be called for in the context of a criminal prosecution. On the other hand, the allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantee of due process of law and gravely impair the basic function of the court. A president's acknowledged need for confidentiality, page 418 U.S. 713, in the communications of his office is general in nature, whereas the constitutional need for production of relevant evidence in a criminal proceeding is specific and central to the fair adjudication of a particular criminal case in the administration of justice. Without access to specific facts, a criminal prosecution may be totally frustrated. The President's broad interest in confidentiality of communications will not be vitiated by disclosure of a limited number of conversations preliminarily shown to have some bearing on the pending criminal cases. We conclude that when the ground for asserting privilege as to subpoenaed materials sought for use in a criminal trial is based only on the generalized interest in confidentiality, it cannot prevail over the fundamental demands of due process of law in the fair administration of criminal justice. The generalized assertion of privilege must yield to the demonstrated specific need for evidence in a pending criminal trial. D. We have earlier determined that the district court did not err in authorizing the issuance of the subpoena. If a president concludes that compliance with the subpoena would be injurious to the public interest, he may properly, as was done here, invoke a claim of privilege on the return of the subpoena. Upon receiving a claim of privilege from the chief executive, it became the further duty of the district court to treat the subpoenaed material as presumptively privileged and to require the special prosecutor to demonstrate that the presidential material was essential to the justice of the pending criminal case. United States v. Burr, 25 F. Cass at 192. Here, the district court treated the material as presumptively privileged, proceeded to find that the special page 418 U.S. 714. Prosecutor had made a sufficient showing to rebut the presumption and ordered an in-camera examination of the subpoenaed material. On the basis of our examination of the record, we are unable to conclude that the district court erred in ordering the inspection. Accordingly, we affirm the order of the district court that subpoenaed materials be transmitted to that court. We now turn to the important question of the district court's responsibilities in conducting the in-camera examination of presidential materials or communications delivered under the compulsion of the subpoena ducis tecum.